which is a decision, or to be more precise, it is a preliminary opinion of the Higher District Court of Munich in a case between HMD and VoiceAge. Here, maybe just very briefly some story behind this case. So there was initially an action filed by VoiceAge against HMD, which is a smartphone manufacturer, regarding SEPs, and there was a decision of the Munich District Court in May 2022, which was in favor of the patent owner of VoiceAge. Here, the Munich District Court also granted an injunction against HMD. HMD then appealed, and I think in parallel there were some complaints filed with the European Commission on VoiceAge's behavior in this context here. So the proceedings moved on to the appeal stage, to the Higher District Court of Munich. And here, in April this year, we had an interesting development insofar as the Commission filed an amicus brief in support of HMD, more or less, where one major topic was the way the German courts interpret the Huawei ZTE framework, and the Commission was of the opinion that you should rather stick to the individual steps one after the other, and believed that there is, let's say, some disconnect between the individual district courts in Germany of how this is applied, so that you needed a clarification of what is the case at the end of the day here. And what happened then was that in October this year, the High District Court of Munich, shortly before an oral hearing in the case, published this preliminary opinion that it has on the case. Again, this is not the final decision. This is an opinion in which the court stresses how it sees things at the moment. This is usually done in German proceedings, mostly to give the parties the opportunity, let's say, to plead things that the court believes are necessary and maybe have not been pleaded yet, or to extend on certain things. So this is something that happens. It is a bit interesting that this is published, because usually it is addressed only to the parties, but this time it was published. And I think it's interesting to take a look at that, because on the one hand, the Higher District Court here does not really follow the Commission's views on how to interpret the Huawei ZTE framework. So it sticks to the case law as it has been developed in Germany, and especially as it has been developed by the Federal Court of Justice in the Siswell Hire cases. But what it does also is to focus a lot on the security payment. And this is what I would like to highlight today, for you to have heard that this is maybe a direction that the High District Court of Munich intends to take, because it is to a certain extent new and not there in the case law in Germany so far. So when it comes to the security payment, generally, where should we locate this within the Huawei ZTE framework? So it is basically the last part of the Huawei ZTE framework. The court had said there you need to make an offer as a patent owner. If this offer is not accepted, then the implementer must make a counter offer. And then, if the counter offer is not accepted, the implementer is obliged to provide security in order to avoid an injunction. So this is, let's say, the last thing that is required from an implementer to do in the context of the Huawei ZTE framework. Here, the court focused a lot on this obligation, and this is relatively new, because in the case law in Germany, this was not really the focus so far. So we had a lot of case law revolving around the willingness of the implementer, which is a bit ahead the security payment. We had some case law on the offer and the counter offer, but security was not so much into the focus. But the High District Court of Munich seems to place some focus on that. And what it said here, and I think that's interesting, is that the security element here and providing security should be part of the willingness assessment. Because the court said here, as we said also in the previous decision, that willingness is something that is continuous, should be there the whole time. So this should basically extend also to whether the patent implementer has provided security if its offer has been counter offer has been rejected or not, which in the eyes of the higher district court means that if there is no security placed by the implementer, as a rule, the infringer, the implementer, will be considered to be unwilling. On the contrary, if you have adequate security in place, then the infringer will regularly be seen as willing. And this is irrespective of its earlier behavior. So irrespective of what he has done before, if security is placed, then basically you will have the implementer to be considered willing. What does this mean? Does this mean that there is no injunction granted automatically if you think that the implementer is willing? No, the court seems to believe here that if there is security in place and you can say that the infringer is willing, then the court will go back to the SEP owner's offer and examine whether the offer is front or not. It will not do that unless there is adequate security paid and you consider the implementer willing. So this is pretty new here because the link between willingness and security payment in the way the court looks at that is pretty new. And apart from that, two final elements which I think are also very interesting. What is adequate security? There was a lot of debate around this topic. First of all, regarding particularly regarding the amount, but from two different aspects. One aspect was, should the amount cover the license on a global level? Or, since we're talking about German litigation, should it be covering only a license at local level, so only a German license for the German part of the portfolio, or even more for the one only patent that has been asserted? And the second one, what should you use as a reference point to calculate this amount? Should it be the offer of the patent owner? Should it be the offer of the implementer? What should be at the end of the day the criterion? And here the court made a clarification: the security amount is adequate only if it would mirror a global portfolio license. So you should mirror what you would pay for a global license, and it should typically be calculated based on the SEP owner's last license offer. So here, and again, the clarification, it's about what the SEP owner requests. That should be the basis for the calculation of this amount. So interesting that the court made this clarification here. But even more interesting is the last part, where the court said, apart from paying this amount, the infringer must commit also in a binding way that the SEP owner will receive the security amount if the court will finally decide that the offer of the SEP owner was front and that the patent was infringed. So the court here seems to go a step further and interpret this obligation to provide a security payment not only as an obligation to pay a specific amount in an escrow account or let's say with a bank guarantee, but also adding to that a commitment in a binding way that this money will flow to the patent owner in case that the court confirms that the offer was front and the patent infringed. So this is again new to German case law and not there in this form so far. So that it would be very interesting to look at the final judgment of the court here and to see if this is confirmed, because if this is confirmed, this could eventually create a new dynamic in the German SEP cases, and this is something definitely to watch, because this could change a bit the way German case law focuses on or is working at the moment. placing the focus more on the security payment eventually rather than the discussion of willingness, etc. So again, a very interesting discussion, a very interesting ruling to be expected here, and we will definitely cover that when it's going to be made public.